Good morning, and thank you for joining us for today's Workers' Compensation 101 webinar. My name is Victoria Vigliotti, and I work at the Board Staff Development Unit. Joining me today is Joe Cavalcante, the Board's advocate for injured workers. Today, Joe will cover the basics of the workers' compensation system, including employees' rights if they become injured or ill on the job, employees' benefits under workers' compensation, how to file a claim, how to get help with your claim if needed, information regarding COVID-19 claims, and tips and best practices for injured workers. We ask you to please keep your phone lines muted as we will be using the chat feature to receive your questions today. You may enter your questions throughout the presentation in the chat box located on the right-hand side of your screen. Joe will answer as many of your questions as he can, but if there are any he doesn't get to, or if you think of something after the session ends, we will be providing you with additional resources at the end of the presentation. Your name and email were given to us when you registered. However, if you have a specific topic you'd like to discuss in more depth with the board, please share that topic along with your contact information in the chat box so that the appropriate board staff can follow up with you. The chat settings are set so that only panelists can see any questions or comments that come in, so you do not have to worry about others seeing your contact information. And with that, I will hand it over to Joe and we will get started.
Thank you, Victoria. Good morning. Welcome to the mid-July edition of Workers' Comp 101. I do hope everyone is both staying cool and is in good shape after those weather events we had last evening. We are going to review the workers' comp system from the top down. So this is our introductory level class. We also had a workers' comp 202, which is a deeper dive into the system, more detail, and we do that about every 6 weeks. The next one, the next Workers' Comp 202 is coming on August 27. So if you'd like to register for that, same way you registered for this on our website, please go on ahead and do that. Let's get started at the beginning. Before there's ever an incident, before anyone's ever harmed, let's talk about how we can create safer workplaces. This is a tried and true method, comes out of the labor movement, frankly. It's called the Labor Management Safety Committee. We have an idea on screen for how you may wish to form such a thing. It's an idea, suggestion. However, the point is, let's talk to each other. Let's have the workers and the managers speak to each other about the places in the work site that could cause an incident or are causing an incident. This is not a claim review. This is devoted to safety. So maybe you want to get out of the conference room, go in the workplace and see what is happening. Maybe you want to perform some safety inspections, do some training for safer processes, okay? Do you have your processes documented? And who's doing the training? So in essence, just make training and for safety and the idea that we can mitigate or eliminate a great number of our hazards if we just pay attention and try. It's free, it's simple, might not be easy, but it's simple, it's free, and the injury you save might be your own. Let's talk now about the system itself. Workers' compensation is a no-fault insurance system. That means, forgive me for stating the obvious, but it's important, we're not interested in fault here. We're not interested in who did what and should they or shouldn't they. Sorry, it's a no-fault insurance system similar to auto insurance in New York. It's also an insurance system. That means that there is an insurance payer somewhere in the mix, and we shall cover that in a few minutes. The employers must provide this insurance coverage for their employees, and the employees do not directly contribute to the cost of this insurance. By comparison, just so you know the big picture, paid family leave, disability, yes, the employees can be asked to contribute something towards the insurance, but not workers' comp. Also, this is a worker's legal right. It cannot be signed away. It cannot be negotiated away. So don't worry about that. What you really need to know, workers, is the benefits I'm going to describe over the next 50 minutes are more of a floor, a minimum. It is possible to negotiate a richer benefit, and that does happen. Also, immigration status of the worker is not a factor. This is one of the few places in the comp system in New York where I can make that broad or categorical statement. Immigration status is not a factor, period. Also, one other important thing to know about, language assistance services are available. So, you do not have to conduct all your business in English, workers, with this agency. We are showing you the webpage, the board's webpage that deals with language, and you can see we have our documents, our public documents, already translated into the 12 languages that well over 90% of New Yorkers speak. If you wish to speak a different language, that's fine. Just tell us. We will provide you a translator for free. Okay? We just need to know, and this is a free service for workers. The Workers' Compensation Board, that's Victoria and my employer. This is a New York State government agency. We regulate the workers' comp system. We do not pay the claims unless, spoiler alert, if the employer is not carrying insurance and should have, we will advance the payments. We'll talk more about that in a moment or two. But we regulate the whole workers' comp system, and we do that because or by receiving reports of all the injuries, all the treatment, all the payments. We receive all of that information, all those documents, and then we can use that to move claims forward or hold a hearing as appropriate. We have almost 1,000 employees in almost 24 offices across the entire state to do all that work. The Advocate for Injured Workers, well, that's me. I actually manage an office of people. We help workers with the most difficult and complex claims. We're also involved in fatality claims. We will discuss these benefits a little bit later. I am actually an ombudsman. That's my real civil service title, an ombudsman or an ombuds. This is a role that some types of organizations have. Hospitals have ombuds, and financial services corporations tend to have them. Universities have them too now. We are a position where we're supposed to be sort of in the middle, and we're supposed to care about the health of the system, the sanctity of the system. Is it functioning properly? And if it is not, well, we bring those issues forward. That is why I report directly to the chair of the Workers' Comp Board, the head of the whole agency, and with that perspective, my office and I can help workers with their claims. And then one of the communities that we work with most closely and most frequently is the 9/11 community, because, my friends, that situation is ongoing. I speak to someone who is at the World Trade Center every single week. So we are showing you right now the web page for the September 11 resources, and we'd like to highlight these three elements in the center of the page. there in teal. Okay, moving across. World Trade Center Health Program. This is a federally funded program to offer medical care and health care to responders and survivors. So if you were there or if you were impacted by those events, would you please register with the World Trade Center Health Program. You are going to get a baseline assessment. You're going to go for annual monitoring. It's extraordinarily good care, and it's not costing you a penny. In the middle, the September 11 Victim Comp Fund, well, there was a great deal of money set aside to compensate the victims of the attacks and of the aftermath. This is maintained and operated by the Federal Department of Justice. We do work directly with the World Trade Center Health Programs. We work directly with the Victim Comp Fund. I encourage you to please check those things out. And then finally, everyone who's in the comp system who is paid to be there, okay, those are employees, yes, workers' comp benefits, but this is the only instance where volunteers can have a workers' comp type benefit, and that is administered through the World Trade Center Volunteer Fund. So if you were there as a volunteer, you should also file the WTC-12 form. Okay? Everyone who's there, who's in the system, file your WTC-12 form so that you can preserve your rights to file a claim should you ever need it. Let's talk now about who is going to pay your workers' comp claim. It's a fundamental question, isn't it? But it's something that sometimes not everyone just addresses directly. So here you go. Remember we said that the employer has to make provisions to have this insurance? Well, there are two ways the employer can have this insurance. The first manner is the employer will simply buy an insurance policy. There you go. And there are about 260 or so insurance carriers who are licensed to write comp in the great state of New York. The largest by far is known as the New York State Insurance Fund, also known as NYSIF, also known as NYSIF or SIF. The reason we're calling them out is we are not them. NYSIF is a different state entity, not the Workers' Comp Board. So I'm just drawing the distinction so you can realize we are not NYSIF. We do not pay the claims until you get to the bottom bullet, which is coming. Now, the other way that the employer can provide the benefits is to self-insure. Self-insurance means that the employer has the financial resources available right now to pay the claims out of its own account. Okay, so obviously we're dealing with an entity that has significant financial resources. Now that breaks down in two routes. Public employers, public as in a state, a city, a county, a school district. The state is not self-insured, by the way. I probably shouldn't mention that one, but it is a public employer. But public employers in New York tend to self-insure, except for the state of New York, which has a NYSIF policy. And they are usually, not always, but usually hiring a claim administrator. This is a third-party administrator or TPA or another entity that is actually handling the claims, paying the claims, arranging for attorneys to come to hearings to represent it, and so forth. So this is a long way of saying, if you're a worker, you are probably not dealing with your employer, or more specifically, your manager, okay? You're not dealing with your HR, you're not dealing with, your personnel office. You're dealing probably with a claim administrator. And so the The other way that I want to mention about self-insurance is it is possible for a very, very large employer to self-insure, such as a private corporation, because they might have the financial resources to do this. Think of like a multinational, maybe multi-billion-dollar employer. They're going to have the financial resources to self-insure. They are going to be permitted by a review from this agency. We check them out thoroughly, and they have to post collateral, and we really do a very good job on that, I have to say. But they also tend to use a claim administrator. It's not mandatory, but it could happen, and it does tend to happen. Finally, let's say that insurance is not in place, and it should be. It's going to go into the uninsured employers fund here at the board. It will be considered like any other claim. If benefits are due, the board will advance the payments, and then we will bill the owners of the scofflaw business directly. So they're going to have to pay penalties, then they're going to have to pay for the claims out of their own funds. So number one, if you have employees carrying insurance, we're going to talk about that. Number two, if you're a worker and you don't know who the insurance company is, don't worry, just file the claim. If you know you got hurt and your employer is not carrying insurance, don't worry about it, just file the claim. All right, let's talk now about the process in a little more detail, as in, who needs a claim? Who needs insurance? Who needs coverage? Well, as we indicated, if you're a business with employees, you need coverage. If you're a business, and business means you're for-profit. If you have one employee, it's your niece who's working for you for the summer, she's getting paid, you need insurance. There's no minimum. You need insurance if you have employees. Most nonprofits with employees are also required to have coverage. Now, we keep talking about employees. Let's define what is an employee. This might be eye-opening for some of us. In the realm of for-profit businesses, anyone who provides services can be determined to be an employee. In the realm of nonprofits, any compensated individual can also be determined to be an employee. There are limited exceptions on the nonprofit front. Some of the easy exceptions are clergy and teachers in a 501c3. Those are the easy, limited exceptions. However, they could still be determined to be an employee because it's the board who determines whether you're an employee or not. What standard do we use? What's our test? Well, it boils down to direction and control. Is the prospective employer exercising direction and control over the activities of the worker? Now, some of the little things that you need to know, 1099, okay? Workers paid on a 1099. That's great. That's a tax arrangement. That does not indicate one way or another whether this person is an employee for workers' comp purposes, okay? The key here is that I can think of at least 5 governmental agencies who are interested in independent contractor status. You have the Federal Department of Labor, you have the State Department of Labor. You have the IRS, you have the State Department of Tax and Finance. And then you have the Workers' Comp Board. What you have to know is that that's 5 agencies. We all use our own law. And each law is different on what's an independent contractor and who's not. So, there's a long way of saying, if you're a worker and you get hurt on the job, file the claim. If somebody who's not the Workers' Comp Board tells you you're an independent contractor or not, you don't have to listen to them. You can file that claim and let us sort it out. This also includes internet businesses, okay? Things like rideshare and task assignment and so forth. There's a lot of feeling in the public, those people are independent contractors and so forth, but I have to tell you, those businesses are carrying workers' comp policies, okay? So there's a reason for that. What do you do if you get injured on the job? All right, this is one of our most important slides right here. You're a worker, you get injured. You're an employer, you're a doctor, you need to know this stuff too because you're right here with the worker. Here's what happens. Worker's injured. Go get medical treatment promptly. Your mother was right. Your health is the most important thing. Go get your medical care now. If you're an employer and you want to take the worker to medical care, thank you. You're doing a wonderful thing. If you want to take the worker to your favorite doctor, maybe don't do that. Do you want to get in the exam room with the worker? Maybe don't do that. Okay? If you're a worker and this is happening to you, you don't have to let anybody in that exam room with you. Okay? That's public health law. That's not even comp. I only mention that because once a month I get a call about this happening. Okay, so now the worker's gotten the medical care at from a licensed provider. You could see any provider in an emergency or an emergent situation, as they say. When you have finished your treatment, catch your breath, tell your employer in writing about the incident. This is a very important step because we need a workers' comp claim to result. Well, you have to tell your employer in writing about the incident because your employer has to now tell the insurance payer. That's a law. If they don't, a penalty can result. Now the insurance payer knows they have to tell the board, us. If they don't, a penalty can result. But the reason this is important is it's starting the chain of events that gives you a claim. One more thing. I said do it in writing. Yes, do it in writing. Do an email, do a document. You are allowed to text. I just don't recommend you text because if you have to show that you did this in 10 months from today, the text very possibly might not be there. Did you know your phone is set by default to save your text for 30 days? You didn't? Well, it is. So that's why I say maybe use an email because there's a beautiful audit trail there. Okay, so now you told your employer. You may also file your own C3 form. This is known as the employee claim. And this is you telling the board, I had an incident, and you're going to give us all of this information. There are a few tabs here. We're showing you the online, okay? You can see these are not really complex questions. There really aren't that many. You can probably answer almost all of them right off the top of your head. The only thing you might want to look up is what you were earning. You can do this online, and Victoria has been popping into the chat all of these links. Thank you, Victoria.
You're welcome.
So feel free to reference that. You can do it online, as I'm saying. I recommend you can unless if you go to do this online and there are some fields that you cannot complete online, then use the paper, okay? The paper is there. You can download the paper, fill it in, mail it in. We will always take paper from workers. We, sometimes demand that providers or professionals or attorneys not use paper, but workers, yeah, don't worry about it. You can do paper. All right, so now we have the claim form. Continue receiving your treatment. Make sure the doctor's office knows this is work-related because we have the claim and we have the notice. That's half of the equation. The other half of the equation is the medical report and the medical bill. So to my friends in the provider community, hi, really glad you're here. You are so important to the workers' comp system. Please be sure to file your bills and reports as soon as you can because these claims don't go anywhere without them. And please feel free to file them as completely as you can, including degree of disability. I talk about that in great length in the Comp 202, degree of disability. But to my friends, the healthcare providers, you need to indicate a degree of disability in these temporary claims, when they're in temporary status, when they're first starting. Workers, you have 2 years after the incident to file a claim. There is a 2-year window of time from incident to report a claim. Yes, I did say tell your employer in 30 days. If I didn't say the 30 days, try and tell them within 30 days. If you don't make the 30 days, you should proceed anyway. But the filing of the claim is 2 years. That's your deadline. And now we're going to have a word from Victoria.
So we will be participating in a survey here and a little quiz. So let's take a look at this scenario. Should Kadir file a claim? Kadir is not an American citizen, but is in the U.S. with a work visa. Kadir works 40 hours a week on site at a software company at an assigned desk using that company's equipment on tasks that the company assigns. Kadir is paid on a 1099, so the software firm considers him an independent contractor. One day, Kadir is inattentive and drops a computer server, fracturing his left leg, and the employer calls an ambulance that takes Kadir to a hospital. So I'm going to be posting a claim or a survey for everybody. If you don't end up seeing the poll in the on the right-hand side of your screen, you can absolutely respond in the chat as well. And I'll give everyone just a minute to answer that.
So should they file a claim? That's the question. Should Kadir file a claim? Yes or no?
I like to leave it open until at least half of the have responded to us.
Okay.
So just so you all know what goes on here on your webinars, we like to see at least half of you respond, and I just need about 5 more of you to give me a yes or a no here. And then we'll give you your grade. Okay, Victoria, look at that. We got to the halfway mark. You can feel free to continue answering, folks. So, Victoria, what's our score here?
So it looks like of our answers, we probably have about a 95% rate that's saying yes, and we have a couple individuals that are saying no.
All right. Those of you who said no, if you want to indicate in the chat why you don't think Kadir should file the claim, please feel free. I'd love to know what you're thinking. But Victoria and I are pretty convinced that Kadir should file a claim. And now remember, we are talking about filing a claim. So the answer could be no, or the decision could ultimately be no, but we're just encouraging Kadir to file the claim and let it be considered, because we do have an awful lot of criteria here that looks like a claim is warranted. You did not fall for he's not an American citizen. Very good. Immigration status is not a factor. We gave you all these reasons to think that maybe he would be considered an employee. You know, 40 hours a week on site. They tell him what to do. He uses their equipment. Okay. They consider him an independent contractor, but what's really independent about that? I don't know. But if a judge has to sort it out, a judge will. The 1099, that's great. But that's a tax and a payment arrangement. Oh, and then you'll notice that when he got hurt, the employer called an ambulance. That's great. I want to thank that employer for caring enough about Kadir's health. That could be construed as the employer having notice of the incident as well, if that was ever a question. So let's hope that Kadir gets well as soon as possible, comes back on the job, and now let's bust on to our next area, we're now going to talk about the benefits of workers' comp. And there are three. There's the medical care, the lost wages, and then finally, the fatality benefit, which we'll consider last. First, medical benefits. No cost to the worker for the necessary treatment of work-related injuries or illnesses. Illnesses count. If they're contracted due to employment, yes. And this, by the way, is a lifetime benefit. That means, my friends, claims do not close unless the worker takes a permanent settlement. Other than that, it's a lifetime benefit. They don't automatically close. You don't need to reopen something. Medical care is your benefit for the course of your lifetime for your established illnesses. And this includes all the typical expenses you would expect, laboratory or radiological testing, doctor's visits, physical therapy. I say doctor, but we also compensate or pay for the services of a PA or a nurse practitioner in the system. Home care is included, DME, durable medical equipment, all of the typical health care. And there's one other thing that's also included, and that is reimbursement of travel expenses to and from care. So Victoria is showing you right now Form C-257. C-257. The top of the form is very simple. What's your name? What's your claim number? But the bottom portion of the form, this is where you put your travel. So you would put, where you went. I went to Dr. Jones on this date and the amount. Okay. Did you do miles? Well, there's a mileage reimbursement rate. Or did you take an Uber or a cab or a train or a bus? You should indicate what you paid there. If you have the receipt, you should probably include that too. So we're just showing you this to let you know that reimbursement for your travel expenses to medical care is reimbursable. There's no deadline either. Okay? If you just went there, you went to your PT 10 times in 2021, you could still submit that. Here is a best practice for medical care. In cases of ongoing disability, and ongoing disability, we're talking about the temporary time. So this is the beginning of the claim, and you are temporary. You should be seeing your healthcare provider every 90 days minimum, more frequently if the provider wants you to come for treatment. But you should go 90 days minimum to find out your degree of disability. How disabled are you? And understand it. Because that's going to be a percentage from 0 to 100%. 0% disabled? You're healthy. Yay! 100% disabled? You can't work. So your benefit amount is going to be based on your degree of disability, among other things. And if that degree of disability is not in the file every 90 days, then the math cannot be performed to calculate your benefit, so you might not be getting your benefit. Okay, and also, give your providers a fighting chance. Show up at your appointments with your WCB case number. That's the one we assign. The insurance company's case number, they give it their own case number. That's fine. Just bring it, please. And finally, the name of that insurance company or payer. Here's another best practice, independent medical exams. You may be asked to attend an independent medical exam. That is when the worker goes to see a provider, almost always a physician, that the insurance payer has hired to give an opinion on some element of your claim. Here's what you need to know. Number one, there's no doctor-patient relationship. Anything you say or do is subject to reporting by that doctor, so be aware of that. Number two, that doctor's not going to offer you treatment recommendations or not going to prescribe something for you at that visit, okay? There's no doctor-patient relationship. Also, you may bring a witness. Don't let anybody tell you you can't, because you can. The witness, or you or anyone, can record the IME, video and audio. You want to use that smartphone in your pocket or purse? Go on ahead. Maybe your witness wants to do that. That's the kind of thing you might do, because you are going to get a copy of the report, and you can compare what's in the report to what's on the video and the audio. And if you have a discrepancy, number one, if you have a lawyer, show your lawyer, because the lawyers do this often enough and frequently enough that they understand some of the processes and tests that go on in these medical exams that a lay person might not. But maybe the lawyer agrees, hey, there's a pretty good discrepancy here. Maybe you don't have a lawyer and you see a discrepancy. You want to report it to the Advocate for Injured Workers. And we'll give you the address at the end of the presentation, okay? Advocate for Injured Workers at wcb.ny.gov. We'll put it on screen. You want to report it to me because we do have a practice committee here at the board that does review these. They do have the authority to revoke an IME license. They can take a doctor out of the system from doing these exams. They can take the license away from the company that hires the doctors also, and that has happened. So you want to send me your complaints about conduct. If the IME says you're 0% disabled and your doctor says you're permanently totally disabled, that's a difference of opinion that's a professional difference. That has to be litigated. I'm talking about conduct. Were you treated in a professional manner? Were all the tests that were reported actually performed, etc.? And then finally, you can claim travel reimbursement to and from an IME, Form C-257, and given the distances people are sometimes asked to travel, you might want to take a good look at that. Victoria, I believe that we might have a question that's just come in that is totally on topic. So what do you think?
So, Joe, do we need to disclose that we're recording during an IME?
No, you don't need to disclose it beforehand. You don't need to say you're doing it. It's probably pretty obvious. But no, there is no compulsion on disclosure of recording by the workers. The IME entity, they have to disclose on the form that they file. So, yeah, you would know if they're recording. Is there anything else in there that we need to be cognizant of? No.
Nope, nothing else about the IMEs.
Thank you, Victoria. All right, so let's go to the next section, workers' compensation, your cash benefits. Your cash benefits are also known as indemnity. That's the system name for this. All right, the maximum you're going to receive in the indemnity lost wage benefit is 2/3 of your average weekly wage. That means we're going to collect the information on all of your employment and everything you've earned. So you have multiple jobs, you need to tell us. You can't work one job, you can't work the other job, you're 100% disabled. Also, all income counts, overtime, bonuses, that kind of thing. You are superintendent of a building in the Bronx and you have a free apartment, you need to tell us because that apartment has a value. And so that goes into your average weekly wage. So we figure out how much you were earning on average for the year before you are injured, and then your maximum benefit is 2/3 of that amount. $900 a week was what you were earning. Your maximum benefit would be $600 a week, 2/3 of that. The new maximum benefit as of July 1. So for injuries on July 1, 2024 forward, it's on screen. 1171.46 is the maximum amount you can receive. That's why your degree of disability is so important. You're 100% disabled, you get 100% of your benefit. You're 50% disabled, you'll get 50% of your benefit. We talk about this in great length in the 202, so please join us on that one in August 27, I think it is. You'll see it. The minimum amount that you can receive is $275 per week. That is for injuries incurred from January 1st forward. And it's going to keep changing because the law was changed last year. And so this year it's $275. On January 1st, it goes up to $325, $325. And then 18 months after that, it's going to be indexed to a fifth of New York State's average weekly wage, average payroll. Our maximum benefit is indexed to New York State's average annual pay. The minimum will be as well. This is an example of when it's a good idea or when it's good for workers to live in New York State, because we have some very high earners in this state, like Wall Street, like the New York Yankees, the New York Knicks. Okay, all of that counts. And when you average high earners in with everyone else, it pushes up your average. Because the average last year was $89,000 per year per worker. All right, let's talk a little bit more about the different types of indemnity benefits. All benefits are temporary at first. Remember the degree of disability, I said temporary. All benefits are temporary at first unless the worker has a permanent injury. Permanent injuries are determined after a worker is as well as the worker is ever going to get. That's called maximum medical improvement, MMI, if you've ever heard those phrases. So you'll be getting these benefits if you can't work. When we come into the area of permanent benefits, it's a relatively small number of workers who have a permanent injury, but permanent injuries go down two roads: permanent partial, permanent total. Worker can never work again. That's a permanent total disability. That worker will receive the indemnity payment for life, the most indemnity that the worker qualifies for. And then permanent partial is you are less than 100% disabled permanently, so you're going to get this benefit for somewhere between 4 years and 10 years. We talk about this at great length in the 202. There's another benefit called the Schedule Loss of Use Award. And that's a benefit that a worker would receive if the injury was causing a loss of use of a limb. Limbs are defined here: arms, hands, fingers, legs, feet, toes. And there's also a similar benefit for vision loss and occupational hearing loss, and even $20,000 maximum for a facial scar. That's a maximum that hasn't increased in the number of years. It's just occurring to me. But those are called schedule loss of use. So the important thing to know there is if you've ever had a claim and if it impacted a limb, did you ever have a doctor assess whether your limb is 100% or not? If not, go to a doctor and have it assessed. Because if it's not 100%, you might qualify for an SLU, schedule loss of use. Here's another best practice. Oh my gosh, I'm going to make this brief because I could talk about this for an hour, but it would be mostly complaining. Please, if you're getting payments, would you please sign up for direct deposit? Please, please, please. I do not understand why anyone who can have a bank account is not receiving direct deposit in the year 2024. Also, if you get paid in cash, that's fine. You might want to keep some records, okay? Write down who paid you, how much, when, for doing what. Because if you have a comp claim, those records are suddenly going to be very helpful. All right, the final benefit we would like to review is the fatality benefit. There is a benefit in this system if a worker should perish due to employment. That includes maybe a traumatic incident that happens on the job and the worker perishes instantly or almost immediately. Also includes if a worker has an established claim and the injuries on that claim end up resulting in the worker's passing. That could be years later, but it's still payable or compensable, as we call it. There are two benefits I would like to share. Number one, funeral expenses, memorial expenses. This is reimbursable. So if you are in the classic downstate area, and yes, this is a New Yorker's definition of downstate, but we are talking about the 5 boroughs of New York City, Long Island, Westchester, and Rockland counties. Up to $12,500 is reimbursable. In the other counties of our state, $10,500 is reimbursable. There are also weekly payments, like an indemnity payment, possible to the surviving family. We look first for a lawfully wed spouse. Gender is not a factor. Then we look to children up to age 18, or if the children are enrolled in higher education, up to age 23. Those children will hit those age maximums and then come off the benefit. And then we also look for disabled and blind dependents. The spouse can have the benefit until the point when the spouse remarries. Spouse never remarries, they get it for life. Disabled and blind dependents, they get it for life too. But the point here is all these people share the one benefit. They share it, and there is a formula. It's not a straight split, there's a formula. If none of those parties exist, $50,000 is payable to the 2 parents of the deceased. If none of these parties exist, $50,000 is payable to the estate of the deceased. If there's a distant relative who comes along, that distant relative has to deal with the estate, not us. Finally, there are 2 scholarships available to the children of workers who've been killed due to employment or grievously injured, either or. And one of the scholarships is available from an organization known as Kids Chance. This is a national organization with a chapter in every state. We are highlighting kcnewyork.org. Okay? If you know someone who this pertains to, then let them know about kcnewyork.org. The other one that we'd like to call out to you is the Triangle Shirtwaist Factory Fire Memorial. This is another nonprofit organization that also has scholarships available for children, similar circumstances, deceased or grievously injured. They are trianglememorial.org. We are not affiliated with either of these, but they are nonprofits. They're doing good work here in my book. I have no problem editorializing there for you folks. Giving a scholarship to a child whose parent was deceased or grievously injured at work, yeah. So you have to go to them directly. Let's talk about COVID claims for a moment, because COVID is still going on. COVID is an infectious disease. Infectious diseases are payable in this system. Okay? Lyme disease, yeah, that's payable in the comp system. So is COVID. Medical reports are going to be key here. So make sure you have something from your test. Okay, if you get a PCR test, file the positive PCR test. If you don't have a PCR test, well, get a diagnosis from a healthcare provider. Because yes, even if you don't have a PCR test, we will take the diagnosis from a healthcare provider of COVID as evidence of COVID infection potentially. You're going to want to talk to your provider about the details of your workplace, regarding what is the likelihood that you got COVID due to employment. Because that's what we're going on here. The likelihood that you got it. Nobody can pinpoint a moment in time when they were infected. So we just need to know what was your workplace like? Did the public have it? Are you dealing with an infected public? Do you work in, say, a hospital? Or do your coworkers have it? Because that is a mode of transmission, my friends, and that is payable in our system. You didn't get it from your public or your clients, you got it from your coworkers. Okay, so that's definitely possible. Finally, you can review a fact sheet and a short video. You can see the URL on screen. Just want to let you know that one of the biggest reasons why you might do this, file this COVID claim, is because of the lifetime medical care. Because people are having COVID symptoms that need treatment over the course of years now. So you would have the lifetime medical care in your comp claim to help you out with this. If you're wondering about when, remember 2 years. Remember, you have 2 years to file a claim. Victoria is pointing out that somebody in the question seems to be asking this. Thank you, Victoria. Yeah, 2 years to file a claim. However, Victoria has more to say on this topic, so I think she's going to give you another quiz, my friends.
Okay, so now we are considering, should Liz file for COVID exposure? So Liz worked at a big box store in the seasonal department during the holidays, dealing with the public. Liz felt ill and called in sick to work, and then her PCR COVID test was positive. Liz did receive paid sick leave for missing 2 weeks of work, and several of Liz's other coworkers had COVID at the same time. So, should Liz file a claim? So I will be opening a poll, a new question for us in just a moment.
Your options again, folks, will be yes or no. And remember, it's file a claim. We're not saying the claim is absolutely going to be paid, but do you think maybe she should file a claim? And then let us determine whether it's payable or not. This is the point where we need music.
Jeopardy music, right?
Or anything. Oh boy, look at this. People are answering this one a lot quicker. I think my math, Victoria, says we've hit the halfway mark.
We have. And it looks like the majority of our participants are saying yes, Liz should file a claim.
I would agree with that statement, would you?
I would. She should
Yes.
absolutely file.
We think she should file a claim. If you think maybe she doesn't have to or shouldn't, feel free to indicate what your thinking is in the chat. What we have noticed over the years is people sometimes say no, she doesn't need to file a claim because she had the paid sick leave. She got paid the 2 weeks that she was off the job. Maybe so. However, please remember the lifetime medical care. That's a pretty significant reason to me why she might wish to file that claim. All right, we're moving towards the end here, and then we'll take your questions. Don't worry about time. We're going to stay and answer all your questions. Let's say claims filed, and we have a complete claim. We have the notice and the medical. Everyone acted very quickly. In that case, benefits must be paid within 18 days of incident or 10 days from notice, whichever is later. The benefits must also be paid within 10 days of the filing of a judge's decision or an appeal decision. 10 days from the filing of that, the money is due. That's a good reason to have direct deposit also. You don't have to wait around for a check. My friends, if you're getting your payments every 2 weeks, great. It's not late until it's 25 days late. That's the actual legal standard. And also to my friends in the payer community, let's say there's an appeal. Let's say that the worker prevails in the appeal and you have to pay money to my friends in the payer community. Don't forget that interest can be due, so please don't forget to calculate those interest payments. You're a worker. Well, you do have a few responsibilities as well. Try to come back to work as soon as you're capable. Now, let's say that you're almost healed, but not 100% healed. Why don't you talk to your employer about the idea of light duty or transitional duty? That just means the employer might give you something else to do other than your regular job that you can do with this smaller degree of disability. That'll get you your full payback, probably. And employers, it's a really good idea for you because there's not going to be any more indemnity benefit paid because the worker's back, so you don't have that pressure on your premium. It's not going in your claim experience. Also, workers, one of the best things you can do is sign up for eCase. We have this lovely tool that works terrifically well called eCase. And Victoria is showing you the website where you would sign up. You can see your entire folder. You can see everything we all see. That big green button there, that big green box, register for eCase. Well, you're going to come and this is what you're going to see. You know, let's give that a click and let's show them exactly how simple this is. Look how simple this is. What's your name? What's your address? What's your email? Oh my gosh, you're almost done. I think we need one little piece of info, like maybe a driver's license, and then you're done. And you can see everything we all see. Really recommend you do this one. The last topic we have for you today is, what should you expect if there's a hearing? Well, we do have these hearings in the system. They will be in front of one of our law judges. You have to know the following. Number one, our law judges, yes, they're rather friendly people. These are not as formal as the hearings you see on television, okay? In a court, number one, we don't operate courts. Number two, we don't use the same rules that they use in civil court or criminal court for sure. There's no bailiff, there's no gavel, there are no gowns. But the point is, it's a little less formal here. There's nothing to be afraid of. Everyone still operates with the same rules of politeness and civility and so forth. The judge is going to make the findings of fact. If you're a worker, you're definitely allowed to have an attorney. Sometimes an attorney is a superb idea, especially if your claim is being formally disputed. That's a great time to have an attorney. A very contentious claim, another great time to have an attorney. Also, be aware, the insurance payer, they're almost certainly sending an attorney to represent them. And now let's talk about the virtual hearing, because this is what we're doing right now. In the near future, we will be back to in-person hearings, but right now we're still virtual, and we're kind of proud of this because we didn't lose any hearings during the pandemic because we had this option. So the virtual hearing, you know, it's essentially a teleconference. Everyone's on screen. The judge, the insurance, the worker, and all the counsels, They're all on screen. No one's in the same room with anyone, with the other parties, okay? Although workers, you could certainly be in the same room with your attorney. Might be a good idea for you. We have an app if you want to get it. Google app and Apple app. We have apps. This is something you do. All you need is a camera and a microphone. That's it. If you cannot do this, you can participate by telephone. You're going to get a hearing notice, my friends, and the hearing notice will have the details on where to go to do the virtual hearing. You'll get like a website address. It'll also have the details on how to participate by telephone if you want to go that route. Just want to let you know, the judge calls you. The judge calls you. If you think your lawyer's calling you, not happening. If you think you're phoning in, not happening. That's why you need to tell us ahead of time that you need the judge to call you. Okay, thank you for listening to all of that. I get a little cuckoo when there's like one tiny little technical thing that's keeping us from accomplishing a task. You know, something that's very simple, like, did you make that phone call? So that's why I dwell on that, because I definitely want you workers in your hearings and understanding what's going on. Along the same lines, here are our social media channels. Feel free to join us on any of these channels. I would like to call out the fourth one down, YouTube. We have hundreds upon hundreds of videos on our YouTube channel, including these videos. Our presentations are saved and they're out there on YouTube, so you can watch one. And then finally, I think we'll read this slide up, Victoria, shouldn't we? This is the contact info for my office. And now I'm going to turn it back to Victoria because it is question time.
What do we do, Joe, if a claim is archived?
You tell the board. We have archived claims because we have, let me do a little quick math, 110 years of workers' comp claims. Actually, our anniversary was July 1, so we have 110 years of workers' comp claims. So tell us, and there is a pretty good probability that if you're archived, we can restore it. There are some claims that might be so old that I'm sorry, we can't restore them, but there's a pretty good chance that we probably can. Your archived, tell us, we'll restore it, and then we'll go on from there. Okay, censor out the name, but go ahead, you can read that.
Okay. Joe, do compensation carriers recognize allocations for disabled children when there's a request to settle on the case?
Wow. We're reading this because this is an extremely complex legal question that I cannot answer. So, in essence, this person is asking whether the insurance company recognizes certain allocations that are made for disabled children when requesting consent to settle. I don't know that insurance companies request consent from anybody to settle. They just make a settlement offer. So I don't know about that. I'm not sure how disabled children would play into a settlement negotiation for a workers' comp claim because they're settling the lost wages and or the medical care. So I'm not sure about how the role of disabled children would play into that. So I'm sorry I can't give you a different answer on that one, but actually based on what I said, I might have actually answered it.
Okay, so Joe, if we receive a subsequent report of injury report type 04, so a denial, Is medical treatment up until that point covered under workers' comp?
Excellent question. I wonder if the person who's posing the question might be from a medical provider. This question has to do with the fact that, number one, insurance payers are permitted to formally dispute a claim. The technical term for that is controvert, as in controversy. Okay, they can dispute it, and that'll happen at the beginning of the claim. And what that means is we're now going to have some hearings over here at the board to review whether the claim is truly payable or not. All right, our worker has been getting medical care. So the questioner is giving the precise name of the form that the insurance payer uses to dispute. It's called a SROI 04, okay? SROI-04. We call that a SROI. That's the form the insurance payer uses to formally dispute. So now the question is, what happens to all that medical treatment? Well, the payer is not going to pay for any medical care that's been rendered or that shall be rendered until the claim is formally established. If the claim is not formally established, which means disallowed, then the provider and the worker, you are free to use some other insurance. Okay, and you're free to work out that payment. But no, they're not going to pay until we have a formal decision on the status of the claim.
When is a check considered late? Can we re-review that topic briefly, Joe?
Yes, we certainly can. Let's say you're receiving ongoing payments every 2 weeks. That ongoing payment check is late if it's 25 days late, 3.5 weeks late. So it was due on the 1st, the 26th has arrived, and you don't have that check yet, that's late. You are eligible for a penalty payment at that point. So workers, if you have an attorney, tell the attorney. If you don't have an attorney, tell my office. Get in touch with us at either that email or that phone number. We'll help you out with requesting that penalty payment.
Joe, what is the maximum and the minimum for the state? This may be referring to our maximum benefit and our minimum benefit rate.
I agree with your judgment there, Victoria. So here you go. We'll give you those numbers again. Maybe Victoria will even type them in for you. All right. Thank you, Victoria. Okay, here you go. The maximum. This is for injuries as of July 1st of this month. The maximum is 1171.46. That is per week. The minimum for injuries incurred in the entire year of 2024 is $275 per week. Now, if your injury was, let's say, happened in 2023 or 22 or 21 or some other year, your max is going to be less because the maximum has risen each year, but your maximum does not rise each year. All right, what else are we looking at, Victoria?
Joe, are these slides available after the webinar on our website, or is it just a recording of the video?
I think it's a recording.
Just a recording of the video? Okay.
Yeah.
And that will be posted?
Yeah, and by the way, if you want to see what the slides were 6 months ago, or 2 years ago, or the first one that we did in July of 2020, because really, we did our first one in July of 2020, we've done it every month since, except August of 21. You can see them. You can see them there. So, yeah. Oh, and by the way, if you have a group and you want me to do a special presentation just for your group, get in touch with me at that email, and we can arrange that. Yes, that is another thing that I do.
And how many penalty payments, Joe, can be issued worker? I assume this means to the worker from the insurance payer. Yes, to the worker. Thank you for clarifying, Rachel.
I love when we say that and people just instantly type in. I love engagement. Well, it's going to be as many as the worker should qualify for, unfortunately. And I only say unfortunately because this is a penalty that you're getting because somebody failed somewhere. But if we have consistent failures, then yes, we can have consistent penalties. There is not a numerical limit to that. All right. You want to give them another minute to see if we have any more?
Sure. Yep, because that's all of our questions that we've received so far.
Okay, we'll stay on here with you for another minute. Someone is giving us a thank you for the work of the medical director's office. So you're welcome. I will certainly pass that on to that office. Oh, wait, something just came in there. I saw something in there. Yes, what is that? I have a question. What happens if my disability? Okay, here's something that's come in. I'm sorry, it's a little imprecisely worded. We're going to do our best, though. If you want to clarify, feel free. What would happen if my disability is suspended? Okay, I think that what you're asking is what should happen if my workers' comp payments are suspended? Well, the key question there, my friend, is going to be why. Why were they suspended? Is it something that can be changed, or is the suspension correct? Sometimes payments get suspended because you're well. You're 100% healed. Or actually, I should say, you have a 0% disability. Okay, that's a reason. But then suspensions can also happen for other reasons. Maybe the IME and your doctor have a difference of opinion. Maybe your doctor thinks you're some level of disabled, and the IME thinks you're 0% disabled. Okay, that's a difference of opinion, and if there's nothing in place saying that payments must continue, payments can be suspended, you probably want to get in touch with us at that point. If that's you, you probably want the board to make a decision on whether your payments ought to continue or not. So get in touch with us in that instance. And it was suspended because the IME already said I need to go back to work full time. Okay, so the person is clarifying. That says to me the IME has you at 0% disability. Okay, if you were getting payments because your doctor had you at something other than 0% disability, if you still have a disability, you might wish to contact us to see if you should have a hearing, to see if your benefits ought to continue, or if you really should go back to work. So why don't you write to us at that email address, and please be sure to just give us your WCB case number. It's going to be 8 characters. It might start with the letter G, like George. Just give us that. We'll look it up, and when we can advise you fully in detail.
So, Joe, what about the decision process? What is the normal turnaround time for that?
Oh, well, that's going to depend on what is the thing that you're asking about. Such as, what do you need a decision on? Did you have a hearing? Well, you could get your decision right at that hearing. You probably will. If not, you'll get a reserve decision. That'll come pretty quickly afterwards. if your claim was appealed, that's going to be some number of months to handle that appeal. So it's going to depend on what we're talking about. Somebody's asking about the 202, aren't they?
Yes. They cannot find the link for the 202.
Okay, here's what we do. Yeah, go to, maybe you want to walk through this?
Yeah.
Okay, Victoria's going to show you. We're going to go to the board website. All right, we're going to show you the big key now, my friends. All right, so we go to our website. We're going to go to the very bottom of the screen, and you'll see this big teal bar. Now, this big teal bar at the very bottom, there are a couple of awesome links in here. One of the awesome links is upcoming webinars.
Okay, see that on the far right there, my friend? Upcoming webinars.
That's where you went to register for this. So there we go. There's your Workers' Comp 202. So you click that, you register pretty quick. How's that for service? And now Victoria's pasting it in. And to our friend who's putting her claim number in the box here, write an email to my office with your question and your claim number. There's no way we can look up your claim here in front of the world. So thank you for understanding that one. Okay, do we have anything else, Victoria, or are we at the end?
We have answered everything so far, Joe. You want to give people maybe 30 more seconds in case any last-minute questions come through?
Yes, we will give you another moment or two here. Victoria's also typing in my office email address. Thank you. It's really helpful. Thank you.
You're welcome.
And anything else, friends, that you want to know? I'm going to sign off and let Victoria give you the formal goodbye now. Thanks, everybody.
So thank you, Joe, and everyone that joined us today. Just a reminder that you can also sign up to receive workers' compensation news, including information on future webinars straight to your inbox. To sign up, visit the board's website at wcb.ny.gov. Scroll down to the bottom of the homepage and select Get WCB Notifications. We do also distribute information via our social media channels, so please feel free to follow the Workers' Compensation Board on Facebook, X, or formerly known as Twitter, Instagram, and YouTube. And we thank you all for joining us, and enjoy the rest of your afternoon.